Mr. President, why are you suing Treasury and the IRS? Why are you suing?
Who are you with?
I'm with ABC News.
You're a loud person. Very loud. Let somebody else have a chance.
Can you answer the question? Why are you suing IRS?
ABC fake news.
You're suing.
Go ahead. I didn't call on you.
In late January 2026, Donald Trump turned a federal data breach into a legal confrontation with the agencies that control American tax enforcement. According to public reporting, Trump, the Trump Organization, and his sons Donald Trump Jr. and Eric Trump filed a lawsuit in federal court in Florida seeking $10 billion from the Internal Revenue Service and the U.S. Treasury Department. The case traces back to former IRS contractor Charles Edward Littlejohn, who, according to court filings, illegally disclosed taxpayer information to news organizations and was sentenced to 5 years in prison. Now, Trump is suing the state that already prosecuted the leak, and the court system is the one place where he cannot set the rules. Starts with the decision Trump chose to make public. He is not asking for an apology or a narrow remedy. He is demanding $10 billion from the IRS and the Treasury Department. According to public reporting, the lawsuit was filed in federal court in Florida and names Trump, the Trump Organization, and his sons Donald Trump Jr. and Eric Trump as plaintiffs. On paper, it reads like dominance, but legally it is a concession to constraint, because the moment he sues the federal government, he enters a venue where procedure controls tempo and statutes control outcomes. The miscalculation sits in how that headline number changes the burden. A demand of $10 billion signals extraordinary harm. And extraordinary harm draws a demand for extraordinary proof. According to public reporting, the complaint describes reputational and financial injury tied to the disclosure of confidential tax information. Those categories are inherently difficult to price, and they are easy to attack as speculative if the pleading does not connect specific disclosures to specific losses. The larger the number, the more visible the gaps become, because the government can press for specificity on how damages were calculated, what business opportunities were lost, and what measurable costs followed from the publications. Institutional resistance is built into the architecture. A lawsuit against federal agencies immediately raises threshold defenses, including sovereign immunity and the limited waivers Congress has written for privacy claims. The government must respond in court, and that response commonly begins with motions that test jurisdiction, the sufficiency of the pleading, and the legal limits on damages before any broad exchange of documents ever occurs. Even if the case survives, the pace is set by the docket and the judge, not by the plaintiff's messaging. That is the destabilizing consequence for Trump's posture. By filing, he reopens a story that already damaged him in public reporting and places it inside a process that rewards narrow framing and punishes exaggeration. He also hands the government an incentive to fight aggressively because conceding in a case about taxpayer confidentiality risks precedent that extends far beyond him. From this point forward, every procedural step tightens the corridor around Trump's options and increases the cost of retreat. Here's turns to the breach record, because Trump's lawsuit is trying to transform a finished criminal case into an open-ended civil payout. According to court filings summarized by the U.S. Department of Justice, Charles Littlejohn, a government contractor working at the IRS, stole tax return information associated with a high-ranking government official and related individuals and entities. Those filings say he used broad search parameters designed to conceal the purpose of his queries, and he unlawfully disclosed return information to news organizations. The Justice Department reported that Littlejohn pleaded guilty in October 2023 and was sentenced on the 29th of January 2024 to 5 years in prison. Public reporting identified the high-ranking official described in the filings as Trump. That procedural history matters because it creates an institutional narrative that is hard for Trump to dislodge. When a perpetrator pleads guilty, is sentenced, and the conduct is described in court documents, the government can argue the system was attacked by an insider rather than acting as an intentional discloser. Trump's posture, according to public reporting, is that the IRS and Treasury failed to prevent the breach and failed to safeguard confidential taxpayer information. But the state can answer with a different frame. The breach was criminal, the actor was prosecuted, and the agencies are already treating it as a security and compliance problem with standardized responses. That standardized response is visible in official communications. In an IRS newsroom statement dated the 10th of May, 2024, The agency said it was communicating with taxpayers receiving a letter alerting them to the unauthorized disclosure of tax return information by a contractor. The IRS referenced Little John's guilty plea and 5-year sentence. This matters because it places Trump inside a wider class of affected taxpayers rather than positioning him as a singular target. It also signals that the institution has a paper trail, timelines, and a bureaucratic process for notification that predates Trump's 2026 lawsuit. A second institutional constraint shows up in procurement. In an official Treasury Department press release dated the 26th of January 2026, Treasury announced it canceled all contracts with Booz Allen Hamilton, citing the taxpayer data breach carried out by a former contractor. The release stated Treasury had 31 separate contracts with Booz Allen, totaling $4.8 million in annual spending and $21 million in total obligations. This is not a concession to Trump's demand. It is the system protecting itself, hardening its vendor relationships, and signaling to Congress and the contractor market that breach consequences are real. Trump's blind spot is that suing the agencies invites the court to focus on narrow legal responsibility rather than broad political outrage. If the government can show it acted through prosecution, notices, and contract actions, it can argue it met its institutional duties after the breach, while still disputing that Trump is entitled to a massive damages award. At the same time, Trump's decision forces him to argue that the agencies, not only the convicted leaker, are legally responsible for the disclosure's downstream effects. That is a high bar, and it pushes the case toward technical debates about waivers, causation, and limits on recovery. By choosing a maximal lawsuit instead of a narrow claim, Trump places his narrative inside a system built to compress narratives, and the pressure begins to rise as the record of institutional response accumulates against him. This is the collision point, because Trump's lawsuit is built to look like leverage, yet the legal mechanics turn that leverage inward. According to public reporting, the case was filed in federal court in Florida and seeks $10 billion in damages from the IRS and the Treasury Department. Reuters reported that Trump alleged the disclosure of his tax returns caused significant and irreparable harm. Public reporting described the claimed injuries as reputational and financial damage, public embarrassment, and harm to political standing. The reporting tied the disclosures to media publications in 2019 and 2020, linked to the contractor later prosecuted. This is where Trump's miscalculation becomes structural. A federal courtroom does not reward magnitude. It rewards fit between alleged facts and the specific legal authority that allows a plaintiff to sue the United States. The United States begins every case with an advantage Trump cannot neutralize, because the government is generally immune from suit unless Congress clearly waived that immunity. Even when a waiver exists, it typically comes with limits that narrow what damages are available and how causation must be shown. Trump's headline number therefore creates two simultaneous vulnerabilities. If the legal framework caps damages, the $10 billion demand reads as overreach. If the legal framework requires detailed proof of loss, the $10 billion demand amplifies every gap in the factual chain. The first institutional resistance arrives through threshold litigation, not through public debate. The federal government must respond to the complaint, and that response can take the form of a motion challenging jurisdiction, challenging the sufficiency of the claim, or narrowing the remedy. These are standard gates the system uses to protect itself from expansive liability, especially in cases implicating sensitive taxpayer information. Trump's posture relies on the shock of a large number, but large numbers do not change these gates. They often strengthen them because the government has more reason to force early rulings that contain exposure. The second resistance is evidentiary. According to court filings summarized by the Justice Department, the unlawful access and disclosures were committed by a contractor who pleaded guilty and was sentenced to 5 years in prison. That history allows the government to argue a separation between the convicted individual and the institutions Trump is suing. Trump, according to public reporting, is arguing that agency failures allowed the disclosure and that the resulting publicity damaged him and his business. But to translate publicity into compensable damages, the complaint must tie specific disclosures to specific harms in a way that survives judicial skepticism. Reputational injury is difficult to quantify. and courts tend to demand more than generalized assertions when the remedy sought is extreme. A fourth resistance is the remedy itself. Even if a court accepts that an unauthorized disclosure occurred, the measure of damages is governed by the statute the plaintiff invokes, not by the plaintiff's sense of scale. That means the judge can confine the case to defined categories and reject any attempt to convert political humiliation into a blank check. Trump's decision to demand a figure of this size, therefore, invites the court to draw bright lines that shrink the case down to what the law is willing to recognize. The third resistance is time. Trump's political style depends on controlling attention cycles, but litigation is a slow machine. Briefing schedules, hearings, and orders impose an external rhythm that a plaintiff cannot accelerate at will. That matters here because the underlying leak story is already widely known, and each new filing renews attention to what was disclosed rather than to what Trump wants to claim. In practice, the court calendar becomes a recurring amplifier of the breach. Now the case enters its most dangerous zone for Trump, the zone where he must choose between breadth and survivability. If he keeps the claim expansive, the government can press for dismissal or limitation on the grounds that the pleading is too conclusory or the remedy is legally constrained. If he narrows the claim, he implicitly reduces the political meaning of the 10 billion figure and invites the public to see the number as messaging rather than law. Either choice is a loss of leverage because it concedes that the court, not Trump, is defining what the dispute is actually about. Discovery makes this dilemma worse, not better. If the case is trimmed early, discovery may be limited, and Trump loses the chance to force broad internal agency documentation into the open. If the case survives and discovery expands, the government has tools to fight for protective orders and to restrict access to sensitive material, and the process can still become a grind, where the institution's patience outlasts the plaintiff's messaging. In both scenarios, Trump's control over narrative timing collapses into calendar control by the court. Meanwhile, institutions are not waiting for Trump's lawsuit to decide how they respond to the breach. Treasury's the 26th of January 2026 press release announced it canceled all contracts with Booz Allen Hamilton, citing failures tied to safeguarding taxpayer data after the breach. That action functions as a public signal. The state is already imposing consequences in the procurement sphere, while the lawsuit asks a judge to impose consequences in the damages sphere. The two tracks interact in a way that disadvantages Trump. Procurement actions allow the government to claim it is responding seriously to the breach, while courtroom defenses allow it to deny liability for Trump's claimed losses. This is the climax because the lawsuit forces Trump into a corridor where every exit has a cost. If he pushes for a sweeping narrative of institutional failure, he increases the chances that a court narrows the case to technical statutory questions and strips out his broader story as irrelevant. If he accepts a narrower legal framing, he diminishes the shock value of the demand and raises the risk that the case is viewed as a political gesture dressed as litigation. Either way, Trump is reacting to the constraints the system imposes, not directing them. The destabilizing consequence is that the case becomes a recurring reminder of the tax leak period, and each procedural milestone renews the original damage, while Trump's leverage continues to erode under institutional control. Follows the institutional counterweight, because Trump's lawsuit is not the only response path available to the state. Agencies and lawmakers can treat the breach as a governance crisis, and governance crises trigger compliance upgrades, procurement discipline, and statutory tightening, all of which operate independently of Trump's courtroom narrative. The most concrete signal is Treasury's procurement action. In an official Treasury Department press release dated the 26th of January 2026, Treasury announced it canceled all contracts with Booz Allen Hamilton after citing failures tied to safeguarding taxpayer data in the wake of the Little John breach. The release stated Treasury had 31 separate contracts with Booz Allen, totaling $4.8 million in annual spending and $21 million in total obligations. This is institutional self-protection, not institutional surrender. It tells contractors that access to taxpayer data is treated as a high-consequence risk, and it tells courts and Congress that Treasury is acting to reduce exposure going forward. The IRS posture reinforces that point. In an IRS newsroom communication dated the 10th of May 2024, the agency said it was contacting taxpayers receiving a letter about the unauthorized disclosure of tax return information by a contractor. The statement referenced Little John's guilty plea in October 2023 and his 5-year sentence earlier in 2024. This is the bureaucratic language of containment. It frames the event as a large-scale compliance incident with standardized notification rather than a personalized injury that requires political negotiation. Capitol Hill has pushed in the same direction. On the 24th of January 2024, House Ways and Means Republicans published a post describing a letter urging the court to impose the maximum sentence on Little John and emphasizing the breadth of the stolen and leaked taxpayer information. In March 2025, the House Judiciary Committee published a press release seeking testimony from Little John and describing the leak as affecting hundreds of thousands of Americans, including Trump, according to its account. These steps do not decide Trump's civil lawsuit, but they widen the institutional perimeter around the breach. More oversight, more documentation, and more incentives for agencies to defend process rather than negotiate damages. Congress has also treated the breach as a catalyst for tougher law. A House committee report on the Taxpayer Data Protection Act, published on Congress, Gov, in 2024, states that the purpose of the bill is to increase the maximum penalty for unauthorized disclosure of tax return information and to ensure each impacted taxpayer counts as a separate violation. That is an institutional response that narrows Trump's leverage in two ways. First, it shifts the public focus from Trump's personal grievance to systemic protection of taxpayer data, which makes his claim harder to sell as exceptional. Second, it signals that the system's preferred remedy for breaches is stronger deterrence and compliance, not massive civil payouts to prominent plaintiffs. Trump's blind spot is that these moves create a defensive wall around the agencies he is suing. When institutions can point to prosecution, taxpayer notices, contract cancellations, and legislative tightening, they can argue they are acting responsibly even as they fight civil liability. That combination limits Trump's ability to claim the government is inert or indifferent, while still leaving him trapped in litigation where his $10 billion demand is a target for narrowing. As the institutional response hardens into policy and oversight, the space for Trump to translate a breach into personal leverage keeps shrinking, and the pressure on his lawsuit grows heavier with every official step taken outside the courtroom. Closes on the reality Trump cannot litigate away. Institutions respond to breaches by tightening control, and courts respond to lawsuits by narrowing claims. According to public reporting, Trump and the other plaintiffs are seeking $10 billion from the IRS and the Treasury Department over the unauthorized disclosure of their tax information to the media. According to court filings summarized by the Justice Department, the disclosure was driven by a contractor who pleaded guilty and received a 5-year prison sentence. According to official statements, the IRS notified affected taxpayers through formal letters, and Treasury canceled all contracts with the contractor's former employer, Booz Allen Hamilton, citing failure to safeguard sensitive data. Those facts create a trap for Trump's strategy. He wants the size of the claim to function as pressure, yet size does not change immunity rules, pleading standards, or statutory limits on damages. If the government persuades the court to confine the case to narrow remedies, Trump risks a public outcome where the $10 billion demand looks like inflation. If the case moves forward into a longer fight, Trump risks a second kind of loss: extended exposure to the very breach narrative he says harmed him, renewed attention to the publications that grew from the leak, and a calendar controlled by a judge rather than by politics. The next phase is procedural and uncertain in timing. The government's first filings can seek dismissal or limitation, and the court can narrow the dispute before any sweeping fact development occurs. That uncertainty does not help Trump, because uncertainty is where institutions conserve power and plaintiffs spend it. The destabilizing consequence is institutional hardening. A president suing tax agencies over confidential records invites defensive lawyering inside the executive branch and encourages agencies to prioritize process, documentation, and risk reduction over discretionary accommodation. Congressional oversight and legislative tightening, already visible in public documents, amplify that pressure. Trump's remaining options narrow to 3 paths that all concede constraint. Pursue the maximal claim and risk early limitation. narrow the claim and accept a visible retreat from the headline number, or continue for symbolic value while the law determines the practical ceiling. For continued coverage of how this case intersects with taxpayer privacy, federal contracting, and institutional power, follow this documentary series.